Hi, I'm Mike Fiffick, and I'm here to talk to you about beneficiary form boo-boos. Many people might not realize that their will does not control who inherits all of their assets when they die. Many assets pass by beneficiary designation, which is the ability to fill out a form with a financial company holding an asset in your name, and it says who will inherit that asset whenever you pass away. Now, assets such as life insurance, annuities, retirement accounts such as 401ks, IRAs, 403bs, and similar accounts all pass by beneficiary designation. In addition, many financial companies allow you to name beneficiaries on non-retirement accounts, which are known as transfer on death or pay on death accounts. While naming a beneficiary can be an easy way to ensure that your loved ones will receive assets directly, you may be surprised how easy it is to make an expensive mistake with a beneficiary designation on one of these forms. So here are 5 critical mistakes to avoid when dealing with your beneficiary designations. First, and most obvious, is not designating a beneficiary. This is the most basic mistake. And what happens when you don't designate a beneficiary is that that money will pass to your family according to the will that the government has for you. And that government will is called the laws of intestate succession. So that money will pass to your estate and will pass in accordance with the government's will. Now, most people that I know don't want the government writing their will for them, and so probably the government's will is not going to work out very well for you and your family. The government doesn't know your family's needs, only you know your family's needs. The second critical mistake involves life insurance. Never designate your estate to receive your life insurance proceeds. In Pennsylvania, life insurance proceeds are not subject to inheritance tax, except when you have them paid to your estate. So that is a real trap for the unwary, naming your estate as the beneficiary for life insurance proceeds. Don't do that. A third critical mistake is not having your spouse on your qualified plan as your primary beneficiary. Now, your life expectancy, the amount that you have to take out of these retirement plans, especially if they rolled over into an IRA, the amount that you have to start taking out after you reach age 71 and a half is by and large based on your life expectancy. And the longer your life expectancy, the smaller amount of money that you have to take out each year. Now, if your spouse is your primary beneficiary, and if your spouse is 10 years or more younger than you, her or his life expectancy are factored into the amount of money that you have to take out of your retirement account on an annual basis. Now, only the money that you take out is subject to income tax, and the rest continues to be tax deferred, and it grows tax deferred. So for most people, they would like to take out the least amount of money that possible while continuing to allow that money to grow in a tax deferred way. You can always take more money out, but you are required to take this minimum amount out on an annual basis. So naming your spouse as the beneficiary of that account can reduce the amount of money that you have to take out from your retirement accounts on an annual basis and reduce the amount of income tax that you pay on that money. Another critical mistake is naming minors as beneficiaries. And minors, I mean children who are under 18 years of age. Minors cannot hold assets in their own name in Pennsylvania. It would be required that that money would have to be held in the name of a guardian or a trustee. Now, if you have no will and you've not named a guardian or trustee to receive money to be held on behalf of a minor, then a guardian is going to have to be appointed to receive and hold that money for that minor until he or she reaches the age of majority. A court proceeding is going to be time-consuming, expensive. It will delay the transfer of that money into the account for that child, and most importantly, you give up the ability to choose who the guardian or the trustee will be to handle that money for that minor. So at the end of the day, what will happen by naming a minor is that less money will get to that minor as a result of this court proceeding, and it'll get there a lot slower. The last critical mistake that you can make with beneficiary designations is not specifying what happens if a beneficiary predeceases you. So you might name one person as the beneficiary. Well, if that person precedes you in death, if you've not given the company instructions on what to do with that money when there's no beneficiary alive to receive it, then that's just like not designating anybody at all. And this is also a problem if you have multiple beneficiaries for designation. So if you're like me and you've got children, and you might say, I want my spouse to receive it, and if he or she is not around, then divide it equally between my 3 children. I have 3 children. Well, if one of them predeceases me, and only 2 of them are alive, the company doesn't know how to split that money unless you've given them some instructions on what to do with the share that would have gone to your child who preceded you in death. Now, the company may just divide that money in 2 parts rather than 3 parts, which may be what you want to have happen, or it may not be. If your child that preceded you in death has children, you have grandchildren through that person, then you may want those grandchildren to receive the share that your deceased child would have received, but for the fact that they preceded you in death. So again, not planning for some contingencies for beneficiaries who precede you in death can be a real critical mistake in dealing with your beneficiary form designations. So these are 5 critical mistakes. I call them the beneficiary form boo-boos. You work hard for this money, and so it really doesn't take much time to plan appropriately to fill out these beneficiary forms in a way to make sure that your family is taken care of. Contact one of our lawyers today to go over your beneficiary forms, and let's make sure that they accomplish what you desire. Thank you.